Welcome to this presentation of criminal trials, sentencing, and appeals in England and Wales, a topic of particular importance for SQE candidates preparing for SQE1 FLK2. Throughout this narrative, I will walk you through the various stages that a criminal case can take, from the initial appearance in the magistrate's court to the appeals process that may ultimately reach the highest courts in the land. My aim is to provide not only the legal framework but also practical examples and illustrations so that you can visualize how the law operates in real-world scenarios. By developing a deeper understanding of the relevant statutes, procedural rules, and guiding principles, you will be better equipped to navigate the complexities of the criminal justice system. This podcast has been produced by Dr. Yannis.glinavos. If you would like to know more about how it was produced, get in touch with Dr. Yannis. Every criminal matter, whether minor or very serious, begins its journey in the magistrate's court. Even when the offense in question is ultimately destined for trial in the Crown Court, the defendant's first hearing takes place before magistrates. This initial appearance might feel relatively brief, yet it sets the stage for the entire proceeding. During this hearing, critical administrative considerations are addressed, including the question of bail, whether through conditional release, unconditional release, or a decision to remand the defendant in custody. The guiding legislation here is the Bail Act 1976, which contains a presumption in favor of bail but also allows the court to refuse bail in circumstances where there is a real risk that the defendant might abscond, interfere with witnesses, or commit further offenses. In practice, defendants who face more serious charges, such as armed robbery or Section 18 grievous bodily harm, may find it more difficult to secure bail, particularly if there is evidence to suggest they pose a risk to the public. After addressing bail and basic case management directions, the magistrates must consider the classification of the offense and whether it falls under the category of summary only, either way, or indictable only. Summary-only offenses are typically minor matters such as low-level public disorder or minor traffic violations and are dealt with exclusively by the magistrate's court. Either way offenses can go to either the magistrate's court or the Crown Court, depending on the seriousness of the facts, the defendant's plea, and the adequacy of the magistrate's sentencing powers. In these scenarios, the defendant can sometimes elect a Crown Court trial, which means a jury would decide guilt or innocence, although there can be practical downsides to making this choice, including increased waiting times and the possibility of higher costs or longer sentences if convicted. A special category of criminal wrongdoing, the indictable-only offense, bypasses most of the magistrate's court process and goes directly to the Crown Court for trial. Under Section 51 of the Crime and Disorder Act 1998, if a defendant is charged with a truly grave offense, such as murder, rape, or certain forms of grievous bodily harm with intent, the magistrates are obliged to send the case forthwith to the Crown Court after completing limited preliminary steps. In a typical scenario, if someone is charged with Section 18 GBH with intent under the Offenses Against the Person Act 1861, that defendant will still appear in the magistrate's court initially. The magistrates, though, have no power to hear the substantive trial. They will consider bail, confirm representation, and then send the matter to the Crown Court for all further proceedings. This sending procedure can sometimes catch either way offenses in its net if those lesser charges arise out of the same facts as the more serious indictable-only allegation. For instance, imagine a case where an individual is accused of armed robbery, an indictable-only offense, and, in the course of that event, is also charged with possession of a bladed article, which is an other-way offense. Since the possession of a bladed article stems from the same incident, Section 51(3) of the Crime and Disorder Act 1998 dictates that this linked offense will also be transferred to the Crown Court. This avoids having the same factual matters litigated in separate courts, ensuring that the entire incident is dealt with coherently in one forum. Once the case arrives in the Crown Court, the defendant will be scheduled for a plea and trial preparation hearing, often referred to as a PTPH. The Crown Court judge will use this hearing to ascertain the defendant's plea and then to plan out the shape of the case going forward. If the defendant pleads guilty, sentencing may follow quickly, or the judge may schedule a separate sentencing hearing if more information is needed, such as a pre-sentence report assessing the defendant's background and risk factors. If the defendant pleads not guilty, the judge will set directions for trial. These directions often include timeframes for disclosure of evidence, the exchange of witness statements, and the handling of any preliminary legal arguments. Disclosure lies at the heart of any fair trial and is governed by the Criminal Procedure and Investigations Act 1996, alongside the Criminal Procedure Rules. The law distinguishes between used material, which is the evidence the prosecution will rely on at trial, and unused material, which is evidence gathered in the course of the investigation but not served as part of the prosecution case. Under Section 3 of the CPIA 1996, the prosecution must disclose any unused material that might reasonably be capable of undermining the prosecution's case or assisting the defense case. This includes witness statements that contradict the prosecution's theory, scientific tests that do not show the results the police expected, or electronic data logs that call the reliability of the prosecution evidence into question. In practical terms, this means that if the police have seized multiple CCTV recordings during the investigation but only plan to rely on the one showing the defendant at the scene, they must disclose the rest of the footage to the defense if it might arguably assist the defendant's position. The importance of disclosure was well illustrated in the case of R. v. McDonnell, 2020. In that matter, the defendant appealed a conviction for robbery after it emerged that the prosecution had failed to disclose witness statements indicating that another individual of a similar appearance had been seen acting suspiciously near the location at the critical time. The Court of Appeal found that this undisclosed evidence could have supported the defense's contention that someone else had committed the crime. As a result, the Court of Appeal quashed McDonnell's conviction, sending a clear message that disclosure failures can devastate the integrity of criminal proceedings. Defendants also have obligations under the CPIA 1996, albeit less onerous than those placed on the prosecution. In the Crown Court, a formal defense statement under Section 5 is mandatory and must outline the general nature of the defense. This is where defense teams clarify whether the defendant is disputing the actus reus elements, the physical conduct, or the mens rea elements, the mental state, or whether they are relying on a complete defense such as self-defense, insanity, or duress. If the defense later raises issues not mentioned in the defense statement, or changes its account without explanation, the court may invite the jury to draw an adverse inference under Section 11 of the CPIA 1996. This does not in itself determine the outcome but can weaken the defendant's credibility in the eyes of the jury. After the PTPH, once all directions for trial are satisfied and the prosecution and defense are prepared, the case proceeds to the trial itself. For an indictable-only matter in the Crown Court, the trial will typically involve a jury, unless the defense has indicated a desire for a judge-alone trial and the court has approved it, which is a rarity. The prosecution will open its case first, calling witnesses to testify and presenting any physical or documentary evidence. The defense then has an opportunity to cross-examine prosecution witnesses, test the reliability of their testimony, and ultimately call its own witnesses should the defendant choose to give evidence or present other forms of exculpatory material. If the defendant is found guilty at trial or pleads guilty earlier in the process, attention then shifts to sentencing. The courts in England and Wales follow sentencing guidelines issued by the Sentencing Council under the Coroners and Justice Act 2009, and much of the sentencing framework is now consolidated in the Sentencing Act 2020. When deciding upon the appropriate punishment, the court will examine a range of factors, starting with the seriousness of the offense. Aggravating features can include previous convictions, the particular vulnerability of the victim, or an offense motivated by hostility towards a protected characteristic such as race or religion. Mitigating features often include genuine remorse, a good character history, mental health issues, or other personal circumstances that reduce culpability. It is also worth noting the role of guilty plea discounts. The Sentencing Council's guidelines on guilty pleas specify that a defendant who pleads guilty at the earliest reasonable opportunity may receive up to a one-third reduction in the length of any custodial sentence. The rationale is that by admitting guilt early, the defendant spares the victim from having to testify and saves valuable court resources. For instance, in R. v. Johnson, 2019, a case involving theft from an employer, the defendant showed clear remorse, cooperated fully with the police investigation, and entered a prompt guilty plea. These mitigating factors, combined with the fact that the defendant had no relevant previous convictions, led the judge to impose a significantly reduced custodial term, illustrating how sentencing can vary according to both the nature of the offense and the personal circumstances of the defendant. When the defendant is under the age of 18, the Youth Justice Framework applies, emphasizing rehabilitation over punishment. Youth rehabilitation orders can include requirements for education, training, or treatment, and custodial sentences for juveniles are reserved for only the most severe offenses. Courts are mindful that younger offenders may have a greater capacity for reform, so the entire sentencing process aims to strike a balance between protecting the public and steering young people away from further involvement in criminal activity. Even after sentencing, the criminal process may continue through appeals. In cases heard in the Crown Court, the defendant has the right to appeal to the Court of Appeal under the Criminal Appeal Act 1968 if there is reason to believe the conviction is unsafe or the sentence manifestly excessive. Procedural irregularities, misdirections in law, or fresh evidence emerging after the trial can form the foundation of a successful appeal. This was exemplified by R v. Patel, 2018, where the Court of Appeal discovered that the trial judge had incorrectly directed the jury on the law relating to joint enterprise, and as a result, the defendant's conviction was quashed. The appellate court made it clear that an error significant enough to undermine the fairness of the trial cannot be ignored. Once in the Court of Appeal, the judges have a number of options. They may uphold the conviction if they find no fault in the trial process. They may quash the conviction entirely if it is deemed unsafe, or they can order a retrial if the prosecution still has a compelling case that merits another chance before a fresh jury. They can also reduce or adjust the sentence, ensuring it fits within the relevant guidelines and does not exceed what justice requires. Appeals from the Court of Appeal to the Supreme Court are comparatively rare and require certification that the matter involves a point of law of general public importance, along with permission from either the Court of Appeal or the Supreme Court itself. Through every stage of this journey, beginning with the defendant's first appearance in the Magistrates' Court, continuing through the complexities of disclosure and trial, and concluding with sentencing and potential appeals, the overarching principle is that justice must be administered fairly, transparently, and proportionally. For SQE candidates, understanding these procedures is not simply a matter of theoretical study. It is an essential foundation for future practice, ensuring the rights of all parties are respected and that the legal system's integrity remains intact. By appreciating how the statutory rules, procedural regulations, and judicial guidance operate in tandem, you will be far better placed to advise clients, draft persuasive arguments, and ultimately contribute to the fair resolution of criminal cases. Thank you for joining me for this more detailed exploration of criminal procedure in England and Wales. Whether your focus lies in advocacy, case preparation, or broader legal strategy, keeping these stages in mind, pre-trial processes, disclosure obligations, trial management, sentencing frameworks, and avenues of appeal will greatly enhance your ability to navigate the system effectively. As you move forward in your SQE studies and eventual legal practice, stay vigilant about ongoing developments in legislation, case law, and practice directions, for these are the tools that shape the continued evolution of the criminal justice process. If you need help with more aspects of the FLK, feel free to have a look around Dr. Yannis' channel. Thank you and see you next time.